The House has resumed. Members, the House, when it rose for the dinner break, was debating the second reading of the Social Security Fraud Measures and Debt Recovery Amendment Bill. Jacinda Ardern has the call. She has just over 4 minutes remaining.
Excellent. Thank you, Mr. Speaker. I will use my 4 minutes as wisely as I can. And before the House rose, Mr. Speaker, I was beginning to talk about some specific elements of the bill, in particular the fact that we have an amendment to the bill now that means a spouse of someone who is accused of welfare fraud, who has not undertaken what could be considered a positive act, can be held liable for that fraud also. And this was a point that was particularly raised by the Law Society, because their argument, their contention was that a positive act is normally required in order to establish criminal liability. And just to be really clear, it's not like a spouse of someone who commits welfare fraud, in particular relationship fraud, can't be held liable currently. I wouldn't want anyone to be left with that impression. In fact, they can, if, for instance, it could be established that someone agreed with the person who ultimately committed the fraud that that's what they would do and they would be complicit in it, that they encouraged or assist them to make false statements in order to commit the fraud, in order to obtain a benefit or a rate of benefit that they weren't entitled to, that they made themselves false statements, for instance, asserted that they weren't in a relationship when they were, omitted to inform MSD of information when asked, attempted to conceal any particular information. So there are a number of ways that if an individual is committing welfare fraud through relationship fraud, that the other spouse can be held liable as well. What this bill does is says that actually if none of those things are present, the spouse can still be found liable if they ought to have known that they were in receipt of a benefit fraudulently. And that's quite a hard test. And so it was probed with some, to quite a high degree, I understand, by the Select Committee. And one of the questions we still came away with was, to what degree could that test be applied, Mr. Speaker, in other forms of fraud? And should it be? If we're going to raise the bar on welfare fraud, and yes, there may be an argument to do that, or there may not, but if we are going to raise the bar on welfare fraud, why aren't we raising it on tax fraud? And I still maintain that that is an absolutely legitimate question to raise, because as I said in my first contribution, of course we are opposed to welfare fraud because it undermines the social security system as a whole. It adds a negative perception to those who genuinely require the welfare state. But in this House, we are constantly debating welfare fraud when tax fraud is of a much higher value to the taxpayer. One final statement I wish to make, Mr. Speaker, is that it has been seen from this side of the House that the government tends to talk about welfare overpayment as being welfare fraud. It's not the same thing. In fact, a large bulk of the money that MSD often is trying to recoup is not fraudulently obtained welfare payments. It's payments made in error. It's overpayments because people are in precarious work and unfortunately their hours which they have to report in weekly are not always in alignment with the hours that are on their payslip, because they're having to guess before they have a payslip in front of them. That is a flaw of the system, not necessarily of the individual. But Mr. Speaker, I look forward to debating that in greater detail at the next stage of this bill.
Pēcera Sam Lotawinga.